Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about myths and jury instructions.
Cases that should have gone to the Supreme Court of Canada, but didn't.
Juries are required to be instructed about certain myths or stereotypes that may come into play in an individual case. And in the case of Nicholas Necan, a First Nations man who was charged with an offense that allegedly occurred after consuming alcohol, the jury was asked to be given an instruction about bias. The defense asked specifically for that instruction to recognize the fact that Mr. Necan was a First Nations person and that there are historical stereotypes and myths about First Nations people in Canada and the consumption of alcohol, including the firewater myth. Unfortunately, the judge chose not to give that instruction. Mr. Necan was convicted, appealed, sought leave to the Supreme Court of Canada, which unfortunately was denied. This case does raise very important issues. Well, it's one thing to say, hey, jurors, don't be biased, don't engage in stereotypical reasoning or myths, or to identify what myths might exist in a certain type of case, like myths and stereotypes that apply to sexual assault complainants, for example. It's another thing entirely to not tie that back to the case. And especially if our justice system is meant to now recognize the historical injustices that have been caused by the colonial system against First Nations people, isn't it appropriate to require then that the justice system includes specific instructions in these types of cases to prevent that type of stereotypical reasoning? Because otherwise, are we not acting in a way that is maybe not inconsistent with Gladue principles, since those that apply at sentencing, but with the idea of it, the ethos behind it coming into the trial process? Shouldn't that be something that's done? Shouldn't we caution juries against specific types of stereotypical reasoning involving specific individual accused persons where they're relevant on the facts of the case? Because otherwise, how can there really be confidence that the jury didn't either consciously or subconsciously engage in this type of reasoning? Is a standard boilerplate stereotype instruction sufficient to correct the colonial harms that continue to be perpetuated in this country? These are the important questions the Supreme Court of Canada could have grappled with had they granted leave in this case. And this isn't just a one-off instance. There continue to be a huge overrepresentation of First Nations people as accused individuals in our justice system. They also continue to be overrepresented in our justice system as victims of crimes. So these instructions become so important because of that historical and ongoing overrepresentation. The Supreme Court of Canada had the opportunity to maybe do something to stem some historical injustices and stop them from continuing, but unfortunately they failed to take that opportunity. Hopefully another case doesn't have to get to this point before the Supreme Court of Canada agrees to hear the issue and provides some guidance in a way that recognizes the impacts of colonization that continue to perpetuate themselves in our justice system today.
Cases that should have gone to the Supreme Court of Canada, but didn't.
Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.